Well, we got tons to get to on this Tuesday with not just the Joint Committee on Administrative Rules taking up the state of Illinois' gun ban rules, the second notice gun ban rules. That happens this morning. You've also got the Southern District of Illinois that is set to hear a challenge looking to delay that January 1st implementation. That's happening this afternoon. But that's not the only thing going on when it comes to litigation against Illinois' gun ban, with that January 1st effective date coming in just a matter of weeks, and a lot of anticipation as to what happens in the courts, especially now that the 7th Circuit U.S. Court of Appeals has denied multiple requests for an en banc review, and the plaintiffs in the Naperville case letting the U.S. Supreme Court Justice Amy Coney Barrett know just that in a filing yesterday. Plus, we'll talk about some First Amendment issues, about the gun industry liability lawsuit, but also a pregnancy center lawsuit that had some resolution. So that's just some of what's coming up here with Bishop on Air. Of course, follow along anywhere. Just search Bishop on Air. All right, so we've got a lot of happenings in the cases against Illinois' gun and magazine ban, including in the U.S. Supreme Court, where the plaintiffs had to notify Justice Amy Coney Barrett that the 7th Circuit U.S. Court of Appeals has denied an en banc review of the 3-judge panel's ruling, vacating a lower district court's preliminary injunction and saying that the state had a likelihood of succeeding on the merits. So you've got the en banc panel being denied. And next step is, of course, the U.S. Supreme Court, where you've got the plaintiffs saying, look at this, Justice Amy Coney Barrett, this is what's happening in the 7th Circuit. Welcome back. It's Bishop on Air. Thanks for following along. You can do this each and every weekday morning, about 7:35-ish we go live, and of course the live show gets segmented out where you can watch this on the channel as well. So appreciate everybody tuning in here live. But let's go ahead and look at the 7th Circuit U.S. Court of Appeals filing here, and this is where you can find these documents. Court listeners, one of them. You've also got Pacer, but you got to pay for that. So here's the statements from the judges of the 7th Circuit. They say plaintiffs filed a petition for rehearing and rehearing en banc on November 8th. No judge in regular active services requested a vote of the petition for hearing en banc, and all members of the original panel have voted to deny a panel rehearing. The petition for rehearing and rehearing en banc is therefore denied. So you had that filed yesterday in the 7th Circuit U.S. Court of Appeals. But what you also had happen yesterday was the plaintiffs in the Naperville case in front of U.S. Supreme Court Justice Amy Coney Barrett. If you recall, they docketed that, and they had a response that was ordered by the state, had to respond by December 6th. The states did just that, and then you had the plaintiffs reply to that. Well, yesterday, the plaintiffs filed a letter to Justice Amy Coney Barrett, essentially spelling out that applicants in the above captioned case noted in their application that they filed a petition for rehearing en banc, and the U.S. 7th Circuit Court of Appeals earlier today entered the attached order denying the petition, and we just looked at that particular order. But again, there were multiple denials with the 7th Circuit because you had all those cases consolidated. And what's important to note here is these consolidated cases were not on the merits. These consolidated cases were on preliminary injunction requests. In the Southern District, you had Judge Stephen McGlynn issue a preliminary injunction that was effective statewide until you had the Northern District cases where several judges in those cases separately sided with the state, saying the state had a likelihood of prevailing on the merits. Those were consolidated in the Seventh Circuit. Seventh Circuit did have one case, the Naperville case, ask the U.S. Supreme Court to intercede and provide a preliminary injunction, but the U.S. Supreme Court did not do that, as the Seventh Circuit consolidated all the cases and put it on what's considered the rocket docket. So you have those cases now, at least when the preliminary injunction phase, no longer in the Seventh Circuit, and I guess you're going to see even more people file to the U.S. Supreme Court. But of course, that first case, Naperville, that is in front of U.S. Supreme Court Justice Amy Coney Barrett. So clearly, there's some fascinating movements when it comes to the U.S. Supreme Court case, the en banc being denied, and what's happening next here. Hannah Hill with the National Association for Gun Rights on Twitter kind of explained next steps here. She says that we have 3 months to file our cert petition, which will be on the merits. In the meantime, our emergency appeal is still pending with SCOTUS, and we're very anxiously awaiting their decision there. Stay tuned. So clearly, you've got SCOTUS that had to be notified of the en banc denial, at least in the Naperville case. So will we see other cases filed to the U.S. Supreme Court to take up the preliminary injunction, or are we going to have some movement on the merits? All of this happening while you've got the Southern District of Illinois today going to hear a challenge on the gun registry. And even Judge Stephen McGlynn, he made clear that the Seventh Circuit was dealing with the Second Amendment gun ban issues. The Southern District's now going to deal with the gun registry issues. So there's a lot more to be said about all of that. But while that's going on, you've got Illinois Attorney General Kwame Raoul, who is working with the state of California in defending that state's gun ban. Attorney General Raoul put out this statement yesterday saying states should be able to protect residents and communities by passing laws restricting the sale and possession of, quote, assault weapons. I will continue to collaborate with my fellow attorneys general who prioritize public safety by defending common sense gun safety measures. The case, Miller v. Bonta, concerns the constitutionality of California's assault weapons ban, and the coalition filed an amicus brief in support of California in the U.S. Court of Appeals for the Ninth Circuit. So Raul goes on to spell out some of the things that he believes allows for states to ban weapons, certain types of firearms. They say it's to protect public safety. Assault weapons are not protected by the Second Amendment because they're not commonly used for self-defense, they claim. California's assault weapons ban is consistent with the historical tradition of regulating and imposing restrictions on new and distinctively dangerous forms of weaponry, they say. So these are some of the arguments that you can see that are going to be made in the ongoing appeals, especially with a state like California that's had a ban in place longer than Illinois, and that case in particular in the Second Circuit has made its way through a variety of hoops as well. So there's a lot of moving pieces on all of this, and clearly it's something that we're going to have to continue to keep an eye on here. So be sure to stay tuned with Bishop on Air. Plenty more to get to. Stay with me. I got to take a break, but we will get lined up with Josh Witowski from an organization that's challenging the gun ban rules. So stay tuned. We've got a lot to get to here with Bishop on Air, all right? So, again, we'll revisit what's going on in the Southern District. You've got JCAR meeting today. Quick programming notes. I'm not going to be live tomorrow. I'm going to be on the road tomorrow. A little bit later on today, not wearing a hoodie, getting ready to throw on a jacket and a tie so that I can get ready to head down to East St. Louis for the hearing with the Southern District of Illinois. I'll explain a little bit of that coming up, but stay tuned. We got much more here with Bishop on Air, live on YouTube, X, and Facebook. Where are we at? Oh, there we are. Okay, stand by. Another busy day in the litigation against Illinois' gun and magazine ban. A little bit later on this afternoon, I'm going to head down to the Southern District of Illinois Federal Court, where Judge Stephen McGlynn is going to be hearing from federal firearms licensees of Illinois and several other plaintiffs trying to get to the January 1st deadline for people to register banned items with Illinois State Police by January 1st. The plaintiffs are looking for that to be ultimately delayed while all the confusion about the gun ban rules gets dealt with. Well, there's a lot of confusion with the gun ban rules, and you've got Illinois State Police who have filed second notice rules. What exactly are those rules? Well, to talk a little bit more about this from IFOR, we've got Josh Witkowski, who's shared some of the responses they've gotten from Illinois State Police on the questions they have. And of course, the Illinois Federation of Outdoor Resources. Josh, you guys focus a lot on, for instance, the issue of how hunters are impacted by all of this. Good morning. Thanks for taking time with us.
Hey, thanks for having me, Greg. Yes, we do focus a lot on how this particular law is going to affect the outdoor sporting community. And the unfortunate reality is that it is going to affect a great deal of firearms owners who are completely unaware that it's going to affect them. There are a large number of shotguns still that are caught up in this mess. We've warned about it for a year now, give or take, and nobody is taking it seriously. Nobody wants to do what is necessary to educate firearms owners. We're doing what we can, but we are a very small nonprofit. Meanwhile, the Illinois State Police, which has the resources of the ability to contact every FOID card holder in the state, just puts things out on a website at a whim. They don't do their best either to educate the public. So we feel there's going to be a lot of individuals turned into criminals on January 1 because of the way this law is being implemented and what the rules are in this law.
So we're looking at a news release that you sent out yesterday that indicates, some of the responses you got from Illinois State Police, and kind of spell that out for us. What are we looking at here?
So if folks remember, I testified back on November 2nd in Springfield at one of the public hearings regarding the implementation of these rules. And what was supposed to be a public hearing with answers turned into a public hearing of, hey, that's a great question, write it down and submit it. So we wrote it down, we submitted them, received a response back on November 21st. And the response is helpful in some parts, nonsensical in others. But this response is now going to become part of the rules that are being considered today at the JCAR hearing up in Chicago. Specifically related to shotguns, two of the big things we were asking, one of the big things was, how do you determine shotgun capacity? Greg, you and I have talked about this before. Is it determined by the maximum number of shells it can hold, or is it determined by chamber size? Now, this is a very simple firearms question that should have been readily answered. And instead, the answer did not come until the middle of the registration period where they're changing these rules. And that answer ends up being they're going to consider it by chamber size. This is going to be helpful to a lot of hunters out there, to a lot of people who have 5-round semi-automatic shotguns. But where it is not helpful is the next thing that's an issue out there, and that's the issue of magazine tube extensions. You can have a magazine tube extension on a firearm. That firearm is now considered a so-called assault weapon. If you take that magazine tube extension off, the tube extension is supposed to then be registered as a assault weapons attachment. The issue is you won't be able to register that after January 1. So if you have a waterfowl gun, which you use an extension tube for when you're hunting geese, you take the tube off when you're hunting ducks, you're not going to be able to use that firearm for both purposes because of the way these rules are being implemented.
Josh, of course, we're kind of skimming through some of what you sent out here as well, and it shows stuff about like airsoft items. Talk a little bit about that, because they did clarify, right? You got the first set of rules that were filed September. Okay, well, I'll let you get there in a moment, but the first set of rules were filed September 15th. this law passed months beforehand, right? January 10th, it was enacted. They wait until September 15th to drop the rules 2 weeks before the October 1st deadline. And now you've got second notice rules. They spell out something about airsoft, but you're saying that they don't make it clear enough?
No, so what they ended up doing, we specifically asked, there's a situation with both airsoft and paintball where you can utilize forward grips, vertical grips, angled grips, which are considered assault weapons attachments because they can be used on modern sporting rifles. Companies such as Magpul, great company out there, you can use their grips on both a modern sporting rifle and on a paintball or a airsoft gun because they use Picatinny, M-LOK, key mod, all the modern styles of attachment points. And when we asked about this specifically, the response we got back was a nonsensical response regarding integral parts of so-called assault weapons, and then says that something specifically designed for airsoft would not be considered. We didn't ask about things specifically designed for airsoft or paintball. We asked about these grips that are compatible with both airsoft paintball firearms and modern sporting rifles. And they did not address that. And by every reading of what they have submitted for second rules, if you have a airsoft or a paintball gun and you have a vertical grip, angled grip, anything that could be attached to a semi-automatic rifle, you're going to have to register that grip. And there's a great number of citizens that have no clue about this.
So I guess the thinking is they could possibly find themselves facing a class 4 felony or a class 3 felony based on the circumstances of how these things are found. What's next here? Of course, I mean, today, later on, it's going to be in federal court. We talked previous segment about what's going on in the Naperville case in the U.S. Supreme Court and the en banc review being denied by the Seventh Circuit. But this morning, you've got the Joint Committee on Administrative Rules that are set to meet. And what do you anticipate is going to happen there from what you're hearing on the ground?
Unfortunately, I have a feeling that this second set of rules that are being introduced today with just 19 days left in the registration period will end up either being adopted by agreement or just by JCAR taking no action. JCAR is 100% bipartisan. They're split equally down the middle between Democratic and Republican parties. It takes a majority to be able to do anything, to change anything. I don't expect that majority to be there today, unfortunately, though I am hoping to be pleasantly surprised. We believe there's some additional information that may come out during the JCAR hearing that is going to be critical to Illinois firearms owners regarding this bill or regarding this law. So strongly encourage people to pay attention to that. And definitely watch that Southern Fifth Circuit. Judge McGlynn's going to take a look at this. I don't know how you can say it's easy for individuals to follow the law when you're changing the rules with 19 days left. And when you're creating situations that, well, I mean, let's go back to the waterfowl gun. Waterfowl hunting is $30 million economic, or not 30 million, $300 million economic impact to the state of Illinois annually, over 25 million in taxes, tax revenue associated with waterfowl hunting. And now, by the way that they've submitted these rules, waterfowl hunters are either going to have to purchase a second firearm for specific use, or they're just not going to be able to use their firearms they're already purchased for their intended use.
It's pretty wild where we're at right now, but obviously a lot of moving pieces, and we'll be tracking that all throughout the day today, as I'm sure you will as well. Josh Rotowski, again with IFOR, greatly appreciate you taking time, and we'll definitely be connecting again soon, all right?
I appreciate it. Thank you, Greg. And if I can, just one last thing. It was said during debate the entire time that sporting arms were not going to be affected, that Illinois Department of Natural Resources was going to develop a list of so-called sporting arms used for hunting. And that did not happen. Basically, they created an appendix. That appendix exists, but it doesn't list out specific firearms. And if you're a hunter and you keep your firearm at home, you still have to register. And that is something that nobody anticipated, because that is not what was covered in debates.
And one thing that's kind of gets muddled in the mix of how laws are made and how bills get passed. Some people already saying in the chat live this morning that Illinois State Police isn't a legislative body. But Josh, you and I have watched how these things get worked through the system, and yeah, they pass a law, and then all of a sudden the administrative agency is tasked with trying to make sense of that, and that just so happens to be what that administrative rule process is. Greatly, again, appreciate you being with us, and we'll definitely talk again in the near future. All right.
All right. Thank you very much.
It is Bishop on Air. Thanks for hanging out as always. And we've got, of course, to continue the coverage of what's going to happen today, because it's not just the Joint Committee on Administrative Rules that are set to meet. You've got the Southern District of Illinois Federal Court that's going to be hearing the challenge of trying to delay the state's January 1st deadline, because if people don't have that delayed, then there's concern people are going to be turned into felons overnight come January 1st. When I chatted with Costas Morris, he's an attorney with Michelle and Associates. He shared kind of, the why this is happening on December 12th, the same day that you've got the JCAR meeting. It's kind of there's a weird what do you call it? Coincidence? I don't know, but either way, today's going to be interesting with JCAR and then the Southern District of Illinois. Here's Costas. And where are you at? Let's get you on. I, for some reason, don't have audio coming from that channel. Just have to see what the holdup is. Here we go. All right, let's crank that up as well. Oh, that's why I didn't have that channel up. Live broadcast, people. Live broadcast here. Here's Costas. Let's get the audio all lined up for you and fire.
And we don't know yet if JCAR is going to approve those. Last time the vote was 5-5. Now, do I expect that vote will hold? Probably, but it's not it wouldn't be insane if one of those people flipped and said no, and then we'll be thrown into chaos. If JCAR rejects the proposed revisions, then we're stuck with the emergency rules, which have all the confusing problems that even ISP admits are confusing. That's why they're revising them. But even assuming it all goes smoothly and JCAR approves the new rules on December 12th, that leaves people just a couple of weeks to register during the holiday season. That's unprecedented, we think, in terms of, you can say that rules being published is sufficient notice, but typically people have months or years before things take effect. Now they have days, We're hopeful the judge will see it our way. And what we're asking for in this motion is you can leave, the state can leave registration open if it wants. If people want to continue submitting affidavits, we have no problem with that. We just don't want the deadline to be enforced until sometime after this litigation has concluded, or at minimum, at least until people have received sufficient notice. And to your point, the state has the FOID data for everyone. Yes, maybe some people change addresses, but if they did a letter, they could get a massive amount of notice out to people. I don't know why they haven't sent everyone a letter about this to give them sufficient notice.
So again, that's Costas Morris, an attorney with Michelle and Associates, representing the plaintiffs, Federal Firearms Licensees of Illinois, versus Pritzker et al. And that case is going to be heard in the Southern District this afternoon, while you've got JCAR meeting in the morning. And again, I'll do what I can to update you. I'm going to head down to East St. Louis. I was going to try to tap into it virtually and take sufficient notes, but I got a message from the court yesterday. It said that the case is set for a motion hearing via Zoom. Per Judge McGlynn, the courtroom will be open for access to the media. As the courtroom will be open, no media will be granted access into the Zoom conference itself, so that means I'm going to have to travel down to East St. Louis and attend this in person. But if you track me on Twitter or X, you should be able to follow along as I can live tweet out as fast as possible from inside the courtroom, so we'll keep you updated there. But clearly still confusion about the rules, and we've talked ad nauseum about the issue of the registration rates and 2.4 million FOID card holders. About 6,400 have registered. The total comes out to around 0.25% last month, when the total was that much. State Representative Bob Morgan, who championed the ban on certain semi-automatic firearms, he talked about what his thoughts are of the low registration rates last month.
This is new for the state of Illinois. As you noted, historically, we've registered people with our FOID card registration, this is the first time we're registering weapons themselves. I also think there are a lot of individuals who have these weapons are considering whether to sell them to someone out of state, which is a provision in the law that they're allowed to do. So I do think this is a function of cramming for the test, that people will wait till the last minute. They'll see there's obviously, we're still waiting for a ruling from the Federal Court of Appeals. Some people are waiting for that. But I also expect that number to increase as people recognize that they want to be law-abiding citizens and they want to be consistent with state law, and they will register their existing legacy weapons. Otherwise, they're risking their FOID card. And I think the vast majority of people are just committed to being law-abiding citizens the way they are now.
So again, Morgan saying it's people cramming for the test and they're waiting for the Seventh Circuit's opinion to drop. Well, that Seventh Circuit opinion dropped, early November? And the number really hasn't changed from where it's at now, 0.25%. I think at that time it was a 0.18% or something. So regardless, you've got these registration rates where people, the Seventh Circuit has made their decision now. They've denied en banc, and it's still being challenged in the courts, not just with the Southern District, but also with the U.S. Supreme Court. So clearly continued moving pieces. Here's Ryan Spain, a state representative on JCAR last month, talking about the next steps here and what the possibility is for, say, a motion to object and to suspend the emergency rules.
We continue to work with the Illinois State Police. They've promulgated emergency rules regarding the registration of certain firearms. They just finished having their public hearings. They had 3 throughout the state. So now it's time to collect all of the feedback, which was very, very extensive. And they've committed to reporting back, answering those very meaningful questions for citizens, for responsible firearm owners throughout the state, and addressing changes that should be made at our December JCAR meeting. Yeah, we need to move quickly, though. We need to understand what changes are happening because there is January 1st requirement. So I think it would be better to see some adjustments from the state police in December rather than waiting for after a deadline has passed and then understanding what changes might be made for permanent rules. Yeah, I think there are a number of unresolved issues, so I look forward to seeing if they come any closer to resolution. I think ultimately we're waiting for some action on this now at the Supreme Court level. The Supreme Court of the United States issues, and I expect that they will at some time. But
the possibility of voting to suspend the rules, which could suspend the rules and possibly leave some questions to be answered as to what the next steps would be after that. But clearly we'll watch all of this. So I promise I'll do my darndest to get you guys updated this afternoon on what the latest is, not just out of JCAR, which if you want to follow that live, go to thecentersquare.com/Illinois. Later on this morning, a live link will be posted where you can watch along live. Again, thecentersquare.com/Illinois. We'll have the JCAR meeting there live. Then I'm going to be heading down to East St. Louis in the afternoon for that open court motion hearing on trying to delay the January 1st deadline. So I'll report about that as well. So a lot of things going on. Of course, stay with Bishop on Air for the latest, and you can subscribe, hit the notification bell. If you enjoy the program, you can check out some of the merchandise below, so be sure to do that as well. All right, coming back, we talk a lot about the Second Amendment, but what about the First Amendment? A couple of different cases that we'll touch on here in just moments. Stay tuned. Hey. A lot of focus lately has been on the Second Amendment, but obviously the First Amendment is also a majorly important civil liberty in this country. Not only do I exercise my First Amendment of being a member of the free press, but also free speech, free assembly. You've got free religion. Religion can be forced upon you. Then you've got the Second Amendment right behind that. Well-regulated militia being necessary for the security of a free state, the right of the people to keep and bear arms shall shall not be infringed. Well, while we track what happens with the litigation against Illinois' gun ban, what about other litigation against First Amendment issues? And one of those things brought up is the issue of the state manufacturers or those associated with the firearms industry geared towards children, or if they have advertisements that are geared towards what the state may consider illegal militia activity. So clearly, there are some questions about the First Amendment in those cases, but there has been litigation against this, and it's been ongoing ever since the measure was signed over the summer. But you have the case in the appeals court, or not in the appeals court, but in the Southern District of Illinois, National Shooting Sports Foundation v. Raoul, and the case, of course, has been filed, and the plaintiffs have had their piece to say. You've also got the Attorney General in the state of Illinois that requested a delay in that case to reply. While they were granted that, and that deadline to file their reply was yesterday. So that was actually filed on Monday. So we've got the state's response here, and it's a 7-page filing, and we'll just kind of go through this a bit. It says that National Shooting Sports Foundation's response confirms this court does not have subject matter jurisdiction. So they're making a jurisdiction argument. They say that NSSF's declarations do not establish standing. The response ignores how the state explained the declarations do not cure Article 3 defects, and no declarant identifies a single dollar an NSSF member lost or will lose due to the law. So it goes on to spell out how they don't have standing. Even more, talking about they can't create a gotcha standing. So some interesting language in this filing. They also argue that the plaintiff's response confirms that it's failed a state to state a claim. So that's another response that the state's throwing out there. And again, these were responses that were allowed to be delayed. So that case is still proceeding. What happens next here? We'll keep an eye on it, because there's various different arguments that you can make about that particular case. But that's not the only First Amendment case that's been moving forward. You had another case, doesn't deal with firearms. It deals with the issue of reproduction, of whether or not somebody who finds themselves to be pregnant, woman goes to a clinic, and that clinic is a pregnancy crisis center that talks about the options that are available, like adoption, or giving them resources to take care of the fetus as it grows, and being able to give them the proper resources. Pregnancy crisis centers. One thing they may not do is talk about, hey, you can go abort that fetus. You can go and have an abortion and terminate that pregnancy. So there are some facilities that don't steer women towards an abortion. Well, the state of Illinois, over the spring session, they passed a law that would allow for the state to go after these pregnancy crisis centers and charge them with deceptive practices. And you had Illinois Attorney General Kwame Raoul even share an anecdote about how he attempted to, test this and was told by one clinic to, avoid, abortions or something to that effect. I'd have to go and look at the archives for exactly what the Attorney General had to say. But regardless, that measure passed, and then it allowed for crisis pregnancy centers that don't offer abortion to be sued by the state. Some people saw that as a violation of their rights. And the National Institute of Family and Life Advocates, they filed a lawsuit, and that lawsuit has now come to a point here where you've got apparently an agreement. So the parties have negotiated an agreed order to resolve this action and jointly move the court to enter it. Pursuant to the court's procedures, a word version of the agreed order will be submitted. So what's interesting about this is the judge had already said, issued a preliminary injunction, by the way, when the National Institute of Family and Life Advocates, when they filed their suit shortly after, the judge came out and said, quote, the law is, and I'm paraphrasing here, likely unconstitutional and stupid. maybe that's a T-shirt for the Bishop on Air store. Likely unconstitutional and stupid. So, the judge in that case essentially signaling how this was going to go and joining the state from enforcing the law. But we've got a statement here from the National Institute of the Pregnancy Centers. They say that the pro-life ministry's victorious against the state of Illinois' attack. They say that, and let me pull this up for you, Illinois Attorney General Kwame Raoul has agreed to order permanently prohibited the state from enforcing the law that declared pro-life speech to be a deceptive business practice and defined as consumer fraud, the sharing of certain information about risks of abortion. Thomas More Society attorneys today filed, together with the Attorney General, a joint motion to enter an agreed order imposing a permanent injunction on the Attorney General. The joint motion was filed in the United States District Court in the Northern District for the signature of Judge Ian Johnson. Again, Johnson had previously said that, here it is, the federal court was spot on in holding that SB 1909 is both stupid and very likely unconstitutional, Peter Breen said. SB 1909 exempts abortion facilities and their speech while exclusively regulating pro-life organizations and their speech in flagrant violation of the First Amendment. So that's an interesting turn of events. That also happening yesterday. So there's been a lot of action on constitutional rights in the state of Illinois where people are trying to challenge state laws, alleging it's a violation of their constitutional rights, and then getting to these types of outcomes. So just some of the other things that we'll continue to track and cover here as you follow along with Bishop on Air. Greatly appreciate you guys tuning in. I got to get the rest of my day going, so be sure to like, subscribe, tell your friends about the live program each and every weekday morning, but also we segment out the clips as well, so that's how some of you ultimately end up seeing these also. But I do have a programming note. I am not going to be doing a live show tomorrow. I've got to be on the road. But we will get you an update on what happens today at the Joint Committee on Administrative Rules. Again, watch the page, thecentersquare.com/Illinois, thecentersquare.com/Illinois. You'll be able to watch along and see that live. That's going to go live at about 10:30ish or so this morning, but it's hard to tell you when J-Car's actually going to come in live because they got their pre-meeting they do beforehand, so it could be 11:30 by the time they actually head into the room in that committee hearing in Chicago. But this afternoon, I'm going to head down to East St. Louis, the court case for the federal firearms licensees of Illinois. They will be in court, and Judge Stephen McGlynn will be, of course, hearing oral arguments in that case. So a busy day today. Got to go get that tie on, get the plan together, and let's rock and roll. Have yourself a great Tuesday. And again, note, not going to be here live tomorrow morning, but there will be some updates later on this afternoon for you. All right, Bishop on Air, signing off. We'll see you very, very soon, I promise. Roseanne, I will try to do a council corral. All right, no promises, but I'm going to do my darndest to get you that council corral tomorrow. So we'll see. It depends on how long the council meeting is tonight, and we're talking about the Springfield City Council. So I'll do what I can to get it for you. I promise. All right. Again, I got to get out of here, guys. And a couple of people say that they would buy that shirt if it said unconstitutional and stupid. All right. The listeners and the viewers have spoken. See if I can make that happen for you. All right, have a great day, guys. I got to get out of here.